If you hold a green card, if you are a lawful permanent resident of the United States, or if you closely follow American immigration news, you have almost certainly seen the alarming headlines spreading rapidly across social media platforms and online news websites over the past several days. Posts are circulating widely claiming that green card holders must report to government offices by 15 March 2026 or face removal from the United States. For millions of immigrants and their families, those headlines sound terrifying and immediate. People are asking urgent questions. Has a new immigration rule suddenly been introduced? Is there a nationwide deadline that every permanent resident must follow? Could millions of lawful residents actually lose their status overnight because of a date they never heard about until this week? These are serious questions, and they deserve serious answers backed by verified facts, rather than panic driven by viral posts. Whenever immigration-related news begins circulating online, fear consistently spreads faster than the truth. Immigration status is not just a legal matter. It is connected to a person's sense of security, their family's future, their employment, their children's education, and decades of hard work and sacrifice. For individuals who spent years working toward permanent residency through legal channels, even the suggestion of a sudden deportation deadline can cause genuine psychological distress. People lose sleep, families hold emergency meetings, attorneys' phone lines flood with calls from worried clients who have done absolutely nothing wrong. But before reacting to viral headlines, before calling an immigration attorney in a panic, and before believing everything circulating on social media, it is critically important to slow down, read carefully, and understand the real story behind these claims. The truth is that there is no nationwide order requiring every green card holder in the United States to report to any immigration office. There has been no emergency law passed by Congress. There has been no executive order signed forcing lawful permanent residents to check in with the federal government before 15 March 2026. The panic spreading across platforms like Facebook, YouTube, TikTok, and WhatsApp groups is rooted in a fundamental misunderstanding of routine immigration procedures that have existed within the system for many years. What actually happened is far more limited and far less dramatic than most posts suggest. In recent weeks, certain specific individuals received official correspondence from United States Citizenship and Immigration Services, commonly known as USCIS, or from Customs and Border Protection, commonly referred to as CBP. Those letters requested clarification about extended periods of absence from the United States. The letters included formal response deadlines. When information about those individual cases began appearing online through screenshots and secondhand reporting, many readers misunderstood the situation and incorrectly assumed that the deadline applied to every single green card holder living in the country. That interpretation is completely incorrect, and understanding why requires understanding what a green card actually means under American immigration law. A green card represents lawful permanent resident status in the United States. The word permanent is critically important here. Permanent residence means that the individual considers the United States to be their primary home. It means their life is centered here. It does not mean someone is prohibited from international travel. It does not mean a permanent resident cannot visit relatives living overseas, attend family events abroad, manage temporary business responsibilities in another country, or take international vacations. Lawful permanent residents travel internationally every single day, and they are fully authorized to do so. The expectation within immigration law is simply that their main life remains anchored in the United States. They maintain a home here, they work here, they file taxes with the Internal Revenue Service every year. They maintain bank accounts, pay bills, and continue building their future in this country. That core principle has been part of United States immigration law for decades and has not recently changed. According to the USCIS Policy Manual, specifically Volume 12, Part D, covering permanent residence abandonment, residency is determined by examining the individual's intention and their continued connection to the United States. The law looks at the full picture of someone's life, not just their travel records. Sometimes travel records show that a particular person has spent unusually extended periods of time outside the country. When that pattern appears in the data available to immigration officials, CBP officers or USCIS representatives may send a formal letter requesting clarification. They want to confirm whether the individual still intends to maintain the United States as their permanent home. These inquiries are a standard part of immigration oversight and do not automatically lead to deportation, removal proceedings, or loss of status. They are information-gathering steps within a structured legal process. The 15 March 2026 date that is circulating widely online comes specifically from those individual letters. Certain residents whose travel patterns raised questions received letters requesting written explanations and providing deadlines for their responses. In some of those specific cases, the response deadline happens to fall on or around 15 March 2026. That date is meaningful and important for the people who received those specific letters, but it applies only to those individuals. It is not a universal deadline for the estimated 13.9 million lawful permanent residents living across the United States. If you are living in the United States as a permanent resident and you have not received any official correspondence from USCIS or CBP requesting information or clarification about your case, then there is absolutely no action required from you before 15 March 2026 or any other date. There is no appointment to schedule. There is no new government form to submit. There is no office to report to. Your green card status remains exactly as it was before these rumors began spreading. To understand this more clearly, it helps to examine how permanent residence and international travel actually interact within the framework of immigration law. Most permanent residents travel internationally throughout the year without any complications whatsoever. They visit parents and siblings in their home countries, attend weddings, manage inherited property, care for elderly relatives, or handle professional responsibilities abroad. These activities are completely normal and entirely permitted under the law. Short trips lasting a few weeks or even a couple of months generally create no concerns at all within the immigration system. The situation begins to become more complicated only when travel patterns suggest that someone may actually be living outside the United States for the majority of their time, rather than visiting temporarily. Extended absences approaching 6 months can sometimes begin to raise questions within the system. Absences close to 1 year or longer may require additional explanation and documentation. These situations are always reviewed individually and depend heavily on the specific facts and circumstances of each person's connection to the United States. To understand the difference between a resident who has nothing to worry about and one who might receive a formal letter from immigration authorities, consider 2 clear examples drawn directly from real-life situations. Consider a permanent resident who lives in California, works full-time at a company based in Los Angeles, files her federal taxes every April, and owns a home in the state. Once a year, she travels abroad for 3 to 4 weeks to visit her aging parents. Her entire life is clearly centered in the United States. In this situation, there is absolutely no reason for concern and no reporting requirement whatsoever. She will not receive any letter. She has no deadline to meet. She simply continues living her life exactly as she always has. Now consider a different individual. He received his green card several years ago, but later moved back to his country of origin to manage a family business that required his full-time attention. For the past 3 years, he has spent most of each calendar year abroad and only visits the United States briefly, once or twice a year, for periods of 2 to 3 weeks at a time. In that situation, official records clearly show that his daily life is no longer based in the United States in any meaningful way. Because of that documented pattern, USCIS or CBP officials may send him a formal letter requesting that he provide a written explanation of his absences and submit documentation demonstrating that he genuinely still considers the United States his permanent home. If he receives a letter with a response deadline of 15 March 2026, that deadline becomes critically important for him personally and for the future of his immigration status. But that deadline does not apply to the millions of other permanent residents across the country who never received any such letter, and whose lives are clearly and demonstrably centered in the United States. Much of the fear spreading online right now is being fueled by myths, misunderstandings, and in some cases deliberate misinformation. One common rumor claims that every single green card holder in the country must register with government offices by 15 March 2026 or face immediate deportation. That claim is entirely false. There is no nationwide registration program for permanent residents, and there never has been under current law. Another rumor suggests that anyone who traveled abroad recently, even for a short trip, may now be at risk of losing their green card. That claim is also completely incorrect. Travel itself is not a violation of immigration rules. Traveling internationally as a permanent resident is a normal, legal, and protected activity. A third rumor spreading across some platforms suggests that green card holders must now carry special documentation proving their loyalty to the United States or face consequences at ports of entry. This claim has no basis in current law or official policy. When confusion spreads at this scale, criminal actors and scammers sometimes attempt to exploit people's fear for financial gain. Some individuals and unofficial services may claim that immigrants must pay fees or hire their services urgently to protect their status before the supposed 15 March 2026 deadline. These scams can cause serious financial harm to vulnerable people who are already frightened. They should be reported and avoided entirely. The safest and most reliable approach is always to rely exclusively on official communication received directly from government agencies. If there is ever a real legal requirement affecting your specific immigration status, you will receive a direct official notice addressed specifically to you by name, with a case number and clear instructions. You will not learn about a requirement affecting your personal immigration status for the first time through a YouTube video, a Facebook post, or a message in a WhatsApp group. Official government requirements come through official government channels. Now let us discuss the practical steps that lawful permanent residents can take right now to maintain their status securely and protect their future in the United States, regardless of rumor cycles. The first and most fundamental step is to always keep your green card valid and initiate the renewal process well before it expires. Processing times at USCIS can sometimes extend for several months, depending on current application volumes. According to USCIS guidance, Form I-90 should be filed within 6 months before the expiration date shown on your card. Starting the process early eliminates unnecessary stress and ensures you always have valid documentation in hand. The second important step involves planning ahead before any extended international travel. If you anticipate remaining outside the United States for an extended period, strongly consider applying for a re-entry permit before you depart. This document, filed using Form I-131, officially confirms that your absence from the United States is temporary in nature, and that you fully intend to maintain your permanent residence upon your return. Having this document significantly reduces the risk of complications when you return to a port of entry. The third practical step is to maintain organized records that clearly demonstrate your life is genuinely based in the United States. These documents include your federal tax returns, filed using IRS Form 1040 for the past 3 to 5 years, current employment verification letters from your employer, lease agreements or mortgage documents showing your residential address, utility bills in your name, statements from your American bank accounts, and school enrollment records for any children living with you in the country. The vast majority of permanent residents will never be asked to present any of these documents to an immigration official. However, maintaining an organized file of this documentation can provide enormous peace of mind and prove genuinely valuable if any questions ever arise unexpectedly about your residency. It is also critically important to understand that immigration law is designed to recognize real-life circumstances. Families face unexpected emergencies. Parents and grandparents become seriously ill abroad. Natural disasters occur. Business complications arise that extend planned short visits into much longer stays. An unexpected and involuntary delay outside the United States does not automatically constitute abandonment of residency. What matters most in any individual case is the person's genuine intention and their documented ongoing connection to the United States. Evidence such as consistent tax filings, active employment relationships, maintained bank accounts, and valid housing arrangements in the country helps powerfully demonstrate that the individual still considers the United States their permanent home, even during an extended absence. Each case is reviewed individually on its specific merits, and individuals are given the formal opportunity to explain their particular circumstances before any final determination is made. According to guidance published by the Department of Homeland Security and CBP Directive 3340-049A, maintaining clear and documented ties to the United States is the strongest protection available to any permanent resident whose travel patterns might otherwise raise administrative questions. Looking at the broader context surrounding this story, the American immigration system operates through structured legal procedures and established legal protections. When legitimate questions arise about an individual's residency status based on documented travel patterns, that person typically receives an official request for clarification through proper channels. They are given reasonable time to respond and the opportunity to submit evidence supporting their continued status. This structured process exists specifically to ensure fairness and legal transparency within the system. Immediate removal from the country without any prior notice, without any formal request for information, and without any opportunity to respond is not how this process works under established immigration law and procedure. For the millions of immigrants currently navigating green card renewals, naturalization applications, family petition approvals, or employment-based visa processes, dramatic and unverified headlines create unnecessary anxiety at an already stressful time. Processing delays and policy updates do sometimes create genuine uncertainty, but viral rumors consistently and dramatically exaggerate the reality on the ground. The most reliable way to stay genuinely informed about immigration matters affecting you is to follow verified official sources, pay careful attention only to official correspondence addressed directly to you, and consult with a licensed immigration attorney if you have specific concerns about your individual case. At the end of the day, the truth behind the 15 March 2026 rumor is straightforward and clear. There is no nationwide reporting requirement for green card holders. There is no sudden crackdown targeting lawful permanent residents who are living normal, law-abiding lives in the United States. The only individuals who must respond by any deadline are those who personally receive direct official letters requesting specific explanations about documented extended absences from the country. For everyone else, daily life continues without interruption. Permanent residents across this country can continue working, raising their families, paying their taxes, traveling responsibly, and contributing to their communities without fear of a mysterious nationwide deadline that does not exist. Immigration headlines will always attract massive attention online, and rumors will continue to circulate through social media with alarming speed. But understanding verified, factual information is the most powerful tool available to protect both your legal status and your genuine peace of mind. According to official USCIS policy resources, lawful permanent residents remain fully secure in their status as long as they maintain their primary residence in the United States and continue demonstrating their genuine intention to call this country home. Rumors can spread in minutes. Facts protect your future. Stay informed, stay calm, and stay focused on the verified truth.